Good evening. Tonight, I'll be speaking with you on professionalism, both then and now. Then being back in the 1970s and the early 1980s versus now. Let's go back to 1974 when I began practicing law. I was an oil and gas lawyer here in Houston, working for Texaco. It was a lucrative job. However, I yearned for a private practice. And so in 1975, I left Texaco and opened my own law office. I took anything that came through the door: civil cases, family, criminal cases, anything that would pay the rent. The Texas Family Code was about 5 pages long back then versus the thick tome we have now. As Martha Bourne mentioned to us in her recent talk, we were making the law back then. The Texas Family Code did not spell it out for us. There were no statutory child support guidelines, no standard possession order, no designated rights for managing conservators and possessory conservators. We didn't even use those terms. And certainly we had no family practice manual to guide us. Each case was dependent upon how the judge ruled based on the facts in that case, without reference to these handy guidelines we now use. So we often talked with other attorneys to find out what a particular judge had ruled in the attorney's case. And many attorneys exhibited professionalism, in my opinion, by giving us advice and helping us out. I was mentored by several attorneys. They told us of their experiences in particular courts. When I first started practicing, I was usually the only female in the courtrooms where I entered. There were other female attorneys at the courthouse: Berta Rayburn, Gazella Solomon, Iris Robinson. But there were so few of us that rarely were we in the same courtroom at the same time. And of course, we had the pleasure of having Judge Ruby Sondak on one of our benches, then called the Domestic Relations Court. There were other female attorneys in Houston, but many were relegated to doing research in the libraries of the firms where they worked. They were typically not sent to the courtroom. And in some courts, female attorneys were not welcome. In one particular civil district court, the bailiff routinely instructed me to move back behind the bars and sit in the pews, that I was not allowed to sit at counsel table. Each time I assured him I was an attorney and that I was going to sit at counsel table. Norma Trush recalls when a family district judge repeatedly referred to her as little lady during a trial, all the time referring to her male opposing attorney as counselor. So there were challenges to being a female attorney back then, and certainly challenges for the attorneys of color. However, back in the 70s and 80s, there was a lot of camaraderie. Many of the judges allowed us to meet in their jury rooms prior to the morning docket call. We drank coffee, ate donuts, visited with one another, discussed our cases, negotiated. We were learning a lot in those jury rooms. Sometimes they were filled with smoke, cigarette smoke and cigar smoke. And yet, we were bonding with one another and we were assessing each other. How was our opposing counsel treated by the other lawyers in the room? How was our opposing counsel treating the other lawyers in the room? We learned a lot, and in spite of all the joking around, there was a lot of congeniality and what I considered as professionalism. The attorneys were well attired. They were dressed in a way that was respectful to the courts. And there was an opportunity for all of us to get to know each other better. With all the security measures at the courthouses now, we don't have that typically, but perhaps a similar thing for us nowadays is to enjoy our team meetings where we can ask questions and learn from one another and become friends. Another way to show professionalism is to be responsive to other attorneys, our clients, and the courts, and to respond in a timely manner. Now, back in the dark ages in the 70s, when we sent an offer, it was by snail mail. So between the time the offer was sent and the lawyer received it, it'd be 2, 3, 4 days. Then the lawyer would copy it and send it to his or her client, another 2, 3, 4 days. And then the counter proposal would be drafted and another few days to send it. So responding timely back then might mean 10, 14, 20 days. Nowadays, there is such a short fuse. I think all of us feel it. A response is often expected within 2 to 3 days, if not 2 to 3 hours. Timing is so important. And sometimes I feel we're addressing speed rather than the message. There's a tension between the speed that is required by technology or that we feel from technology versus the time that professionalism requires in our cases. And often these two elements put us in a tug of war. So even now, it is important to read and reread our correspondence, our pleadings, edit them, check your wording, and think about how would a third party feel about these words? How would the judge look at this? How about a state bar grievance committee? So I feel that this is a big difference between then and now, and it's very important for us to give the time and attention that a particular document is needed. Also, I think it's important to return our phone calls in a timely manner, just the way it was back then. And I think it's important to dress in a manner that's respectful to the court, whether that's in person or on Zoom. And I believe this is true for both men and women. So then and now, it's important to be professional in what we write, what we say, how we act, and how we go forward in our cases to bring them to resolution. Let's always be mindful that our cases can affect our clients for the rest of their lives. And let's do our best to handle their cases in a professional and courteous manner. Thank you and good evening.
Good evening. Oh, you caught me. I'm trying to put this toothpaste back in the tube. It reminds me of tonight's story. Meet Rachel and her client, Kim. Rachel is a young lawyer helping Kim with answers to her interrogatories. Kim presents a problem for Rachel. Kim would rather not tell the truth, even if the truth would benefit her. Kim can rationalize anything, and Kim knows more than anyone. In our story, the rubber meets the road when Rachel tries to educate and communicate with her client.
Hi, Kim. Thank you so much for coming by the office today to finish our discovery responses. I appreciate you taking the time.
Rachel tries
yeah, I'm
to
going to talk about
straddle the
these. They were
center
kind of
line
personal.
by not asking
so let's talk about some of those interrogatory questions.
But if she
Specifically, I want
listens
to go
to her
over
client,
the answers
she
to
may
some of
well
those
find
interrogatories that
herself
you gave me. We're missing
between the
answers
rubber and the
2
road.
and 4.
Tonight's
If you recall,
story
answer number 2
is
asked if you
entitled
had any intimate
Road
sexual
Rash.
contact with anyone other than Sam, your husband, during the marriage. You remember that question?
Yeah, but I don't see how that's any of his business. I mean, he's the one who checked out of the marriage 2 years ago and moved upstairs to his own bedroom.
I mean, and I get it. I totally understand. However, there's no legal separation in Texas, which means, you know, you're still married until you're divorced. And he's alleged adultery against you, so it is relevant.
But he has no proof, and I'm not the one that's going to hand him the proof.
Are you saying you're going to risk perjuring yourself? You understand that these questions are under oath, right?
Yeah, I do, but he's never going to find out about Ryan. I mean, Ryan would never say anything to anybody.
Okay, we're going to circle back to this. Okay. Let's talk about the other interrogatory that wasn't answered, number 4. You didn't answer that one either, and that one asked, have you ever taken any illegal drugs during the last 2 years?
I mean, again, that is none of his business.
But Kim, he asked for random drug testing, and what are you going to do if the court orders you to test?
Well, I thought about that, and I took a test last week, and it came back clean. So he's only guessing and doesn't have proof of anything.
Okay, so that means you haven't done any drugs in the last 2 years, right?
Well, no, I mean, I have, but if I tell him about it, he's going to take my kids away from me.
So you want to lie on this answer too?
If the drug test is clean, why does it even matter?
Kim, I just want to clarify. I just need to know that you're saying what I think you're saying. You're saying that you're okay with lying on these answers?
I mean, he's one to talk. He's the liar in this situation.
What do you mean? What are you talking about?
I mean, so he was in a car accident a year ago, and I had to do a deposition. And of course, because of COVID, it was by Zoom. He sat outside of the wall where I was doing the deposition. And if he didn't like one of my answers, he would bang on the wall. And that's why I would know to change my answer. So I had to do and lie if he told me to. So he's a liar.
Wow. But didn't you sign a transcript to verify your answers?
I mean, they mailed me something to sign, and I signed it and sent it back. Was that under oath or something?
I mean, yeah, it's under oath.
I didn't realize that.
Okay. So we're not going to answer, you're choosing not to answer truthfully the interrogatories that were asked?
I'm just not going to hand him information that'll screw me in court.
Oh, you're back. I'm still trying to put this toothpaste back in the tube. Seemingly, clients continue to misbehave, making it that much more important that lawyers proportionately behave that much better. The first line of the Texas Lawyers' Creed states, I am a lawyer. I am entrusted by the people of Texas to preserve and improve our legal system. Rachel's problem was not Kim making poor decisions, but how to preserve our legal system by helping Kim make the right decisions. Instead of letting Kim define the problem and then allow her to rationalize the problem through her narrow lens, the problem should have been addressed at their first meeting. Although the creed was probably attached or referenced in her contract of employment. She didn't advise her client of the contents of the creed when undertaking representation. Also, she might have said that professionalism requires more than merely avoiding the violation of laws and rules. And she could have taken the one additional minute to tell Kim, I am committed to the creed for no other reason than it is right. Good evening. I rescued this longtime enemy of Elmer Fudd from a cauldron of boiling liquid. I'm sure many of you feel the need to be rescued from these uncertain times where the stress of our practice has created cracks in the dam protecting the fundamental elements of professionalism. Tonight's play is about an attorney, Carl, who represents Milton Franks. Carl comes into the case as the seventh lawyer. His methods are to strong arm and to misuse the legal process. Alex represents Dolly Franks. Alex has to deal with a custody modification. Milton, the court, in a serious case of alienation. This true story resulted in a trial which had a sordid and disturbing conclusion. This is entitled Divide the Bunny.
Hello?
Yes. I'd like to speak to Alex Johnson, please.
Yes, hi, this is Alex.
Yes, I'd like to speak to the lead counsel on the Frank matter, Mr. Alex Johnson, not his paralegal. Do you know when Mr. Johnson will be available?
Mr. Copeland, hi, yes, I'm the lead attorney on that file and I'm not the paralegal. How may I help you this afternoon, Mr. Copeland?
When did Joe start hiring female attorneys? Well.
Excuse me?
Well, first off, you can smile for me. It's so much easier to work with a woman when she's smiling. You know what I mean?
Ugh.
Well, Joe must not think much of this case to have you on as lead counsel, huh? Don't you think?
Mr. Copeland, for the last time, how may I help you on the Frank matter?
Okay, baby cakes. Let's get down to business. Well, I want to talk to you about a couple of things. First, let's talk about your disdain for my client, Mr. Milton Frank. You could not be more wrong about him as a father or for a human being for that matter. And if you continue to malign and assassinate his character, you and your partner may find yourself in a rather uncomfortable situation involving defamation. There's a line that a lawyer can cross in the context of litigation, and you just make sure you don't cross that line. We will treat your client with the respect she deserves as long as you treat our client with the respect that he deserves. You got it?
Okay.
Well, next, let's talk about your client's medical charades. We intend to address these issues with the court ourselves. There's no doubt to say your client has a medical addiction to prescription drugs.
More conclusory statements and not an ounce of evidence.
Well, what would you say to her mental condition and her mental issues? Why don't you state whether or not you are opposed to a psychological evaluation of your client, Mrs. Dolly Frank? It's time for her medical charades to end. Who's gonna address the issues of all the prescription drugs your client takes and how that's going to affect this case and the children of this case?
Honestly, Mr. Copeland, I think you need the psychological evaluation.
Really? Well, back to business. Are you going to answer our discovery? Your failure to answer the most recently served discovery in this case constitutes a patent abuse of the discovery process. And normally, I would allow more time, but on the account of your recently filed and set motion to compel, you now have 10 days to supplement or agree to supplement, or we will be forced to seek attorney's fees along with our motion to compel.
Ooh, motions to compel are so scary. Send me a deficiency letter.
Lastly, I know your client is dead broke, and you will reveal the source of funding for your client's bogus case. And you better pray it's not from one particular source, or each of you and every member of your firm will likely be put under an unusual microscopes, which you probably do not want.
Count your own quarters, Copeland. Any more idle threats?
I'm glad you asked. We are requesting that you account for the transmittal of all documents and data in this case. Please state whether or not you agree to a confidentiality order as provided in the motion to seal.
We do not agree. Next.
Fine, we'll just file our motion. You know the court's going to grant it.
Do what you have to do, Mr. Copeland.
Please state whether or not you agree to our motion for substitution of counsel.
Not today, I'm not.
Oh, you're absolutely ridiculous. So now you're going to make me set the motion for substitution for a hearing, more needless and senseless litigation cost?
Well,
how about Patricia Barton as the custody evaluator? How about that? Can you agree to that?
I don't believe she's qualified. We would much rather prefer Shanna Lott.
So we're going to have to set that for a hearing too, aren't we?
I guess so.
Well, how about having the children confer directly with the judge in his chambers? How about that?
Mr. Copeland, you know we are opposed to having the children confer directly with the court. You know they're not mentally stable to deal with the stresses of this divorce. So until we get clearance from the children's psychiatrist, we don't agree to that motion.
Well, let me tell you what we don't agree to. We don't agree to trying this case next month, but make no mistake about it. We're here to try this case and bring all of Dolly Frank's hidden conduct to light, and the fact finder make a reasonable decision in the best interest of the children. I think you'll find that we are compassionate, or at least reasonable people. It's just that you found yourself on the wrong side of the case, and you've allowed your client to lead you astray. Your client, who is an abusive woman, who is also a fugitive from justice, and you and members of your firm must be abusers yourselves to sympathize with her. Either way, we're here to bring Mr. Frank that justice and restore some peace to him and his children.
I'll be ready for you at trial. Is that all, Mr. Copeland? Anything else?
No, actually, it's not. We're going to pay a visit to Dolly Frank's house for a brief inspection under the request for entry onto land pursuant to the rules, okay? It shouldn't take more than an hour. Please provide the dates and times you and your client are available. And if you fail to agree to provide reasonable access, as I am requesting here, you can count on a short motion for entry onto the land, also to be presented to the court at our next hearing, along with everything else. Please just tell me whether you agree or not.
You know you have absolutely no basis to enter my client's home. We are not agreeing to that motion.
Also, we're waiting to hear from you regarding your alleged discovery complaints. If you got time to file a motion, you've got time to pick up the phone. We're pleased to provide you whatever relevant and material items, because based on the clear facts of this case, as applying to the law, I can hardly imagine how, unless you're missing something, you could remain completely blind to the fact that you've got no case at all, and by all accounts, you've never had a case. On another note, have you received and reviewed my motion for Rule 204, mental examination of Dolly Frank?
Yes, I've received your baseless motion, which starts off by saying, the evidence will show she has a history of domestic assault, physical violence, physical abuse, emotional abuse, financial abuse, illegal abuse, antagonism, and controlling behavior. Abusiveness is a cycle, and there's no evidence that Dolly Frank has extinguished any of her negative behaviors, including her seemingly lack of interesting and warm and caring interpersonal relationships. The children's emotional development is at risk if primary residence remains with Dolly Frank.
It's true, you know. And the mental examination also says that it'll lead to relevant evidence which may explain the bizarre and abusive conduct and may pave the way to bring peace to this situation. Dolly Frank need not be ashamed of the potential need for mental services, as she may well be a candidate for such services depending on the outcome of one or more examinations. Oh, and let it be known that there are no less intrusive ways of me getting this information. The evidence may very well show that Dolly Frank acts with sociopathic tendencies, among other things, a possible autism spectrum disorder, and mania of depressive episodes, and schizophrenia and antisocial personal disorders, and borderline personality disorder, and maybe some historic personality disorder, and definitely narcissistic personality disorder, and paranoia personality disorder, and schizoid personality disorder, just to name a few. It will be important for the court to know these details in determining the best interest of the children in this case. And again, there are no less intrusive means of me getting this information than to request a mental examination of your client.
Sounds like a fishing expedition to me. This motion is laughable and absolutely baseless, and it displays in a disgusting manner the type of attorney and human being you are. Your actions will destroy these children. This is more hideous than the notice to take my deposition by written questions as a non-party, and the notice of deposition and deposition subpoena, which schedules my deposition as a non-party and as counsel of record for the petitioner. But please note, sir, I was not personally served pursuant to the rules, and I do not waive personal service, nor have I ever waived personal service. We will have a motion to quash on file today by the end of the day. Mr. Copeland, you're a real piece of work.
We're just getting started, baby cakes.
During the trial, the dam broke. The fundamental elements of professionalism were challenged. It was discovered Carl and Milton were emotionally and personally involved. Relationships with clients, relationships with the court and other lawyers were challenged to the end. Dolly was named primary of the two younger children. The oldest was 18 and alienated beyond description. He went with Dad. Shortly after trial, Milton abandoned his oldest son. Dolly again had a relationship with her older son, and the boys were reunited. Ultimately, professionalism won.
All right, so we are going to talk a little bit more about professionalism. And one of the big things I think Judge Valdez and I wanted to talk about is professionalism in the courtroom, especially in the Zoom era. Judge, what kind of things should attorneys and their clients be expected to maintain when they are in your courtroom handling a case via Zoom?
Well, as always, when attorneys appear in court, they should always keep in mind what the Texas Lawyers Creed demands of the relationship between the judges and attorneys. And that is always that both the judges and lawyers owe each other respect, respect, diligence, candor, punctuality, and the protection of unjust and improper criticism. So incorporating all that in today's world of Zoom, we want to keep in mind that while Zoom is sometimes used as wine night for girls or family gatherings or spending Christmas with family and getting to reconnect with those we haven't seen. Zoom utilized in the courtroom still demands that professionalism as if you were in person. So we want to make sure that you still, as lawyers and for your clients, you're still viewing this as a courtroom proceeding, as if you were standing in front of the courtroom, or I'm sorry, in front of the bench in the courtroom with your clients. So we should talk about being appropriately dressed. Neither lawyers nor clients should wear baseball caps or informal outfits or any outfits that you wouldn't wear in person. You want to make sure that you, actually your client has a shirt on. I think both Judge Salvini and I can speak to that. Make sure one instance is like if you tell, or if the court has to tell your client to go put a shirt on, make sure they don't carry their phone to the restroom with them while they're putting the shirt on, and then you can see everything in the restroom. That's one instance that we've had that. So making sure that the dress is appropriate for a court proceeding.
I agree. And like we previously discussed, I've had to tell gentlemen to put their shirts on, or I know I've had people in their bathrobes.
Yeah.
But like you said, we still are in court, so still try not to be eating while you are in court. I know both of us have had that as well. But the big thing is your attire. You are still in court, and so please be dressed appropriately. And one of those things that you mentioned, if we do have to tell your client to go put a shirt on, to tell your client to put themselves on mute or stop the video.
Yes.
Along those lines is teach your client how to use Zoom.
Correct. I think so many clients are appearing and they don't know how to connect via video, or they don't know how audio is supposed to work. So they really need to be well versed in navigating the Zoom hearing itself, as well as knowing what they're supposed to say and do, and how to behave during the court proceeding in a Zoom setting. I think another thing too is that lawyers and their clients should be very punctual. Zoom provides the avenue that you can actually go onto the link and be present in the waiting room before the judge actually starts the hearings. So make sure you're at least 5 or 10 minutes early. With Zoom, you can pop it on. You want to mute yourself. You want to turn your video off until you basically hear that ding that court is starting. And then at that time, put your video on, keep your audio muted. And you want to make sure that your client knows to have their video on and audio muted. It's very disruptive once the docket's being called and there's a lot of background noises going on.
I agree. And I tried to make that announcement at the beginning of every docket that I do call to, if your case is not being called, please mute yourself. But, sometimes people don't know how to mute themselves. Even attorneys sometimes don't know how to mute themselves. And attorneys are sometimes in dockets in multiple courts, so they have multiple devices going. And while that's understandable, I don't need to hear what's happening in another court because they have failed to mute themselves.
Right. And another area too is that while you want to be punctual, you also want to be stationary. Neither the lawyer nor his or her client should be driving. That is called distracted driving, and it could lead to accidents. And I know personally, I don't want to be responsible for someone having an accident because they need to appear before me. And I'm sure you, Ryan, you're the same way with that.
And I get motion sickness, to be honest. Even if you're not the driver, if you're a passenger in the car, just seeing the background and the bumps and
Exactly.
The phone trying to connect to the Bluetooth in the car, it's very distracting. And like I said, I get motion sickness to an extent to where it's very distracting just for the court to not have an attorney or their client being stationary. And along those lines also, I understand that sometimes people are not wanting to be disruptive, so they step outside.
Right.
The wind also creates a huge distraction in terms of the audio quality. So try and make sure when you are talking to your client or even yourself, I believe I had an attorney one time who was attempting to fish while he was on Zoom. That audio quality isn't great if a party or an attorney is outside.
Agreed. And it is very distracting when you see a client walking around with a cell phone and trying to get stable. That's why it's so important that both you and your client are at least 5 to 10 minutes early on that Zoom call, so that when the court does come direct on in session, your client's seated, undivided attention for your client to pay attention to what's going on with instructions. Also, neither the lawyers nor the clients should be attending any other appointments while appearing for a Zoom hearing. They should not be at a doctor's office. They should not be at a dentist's office, and especially not at hair appointments in your hairdresser's chair with foil in your hair. I've had that happen, and it's very disrespectful to the court, because in essence, what you're saying is, I've got more important things to do than to appear before you, judge, and I'm going to make you ancillary to what I'm conducting at this time. And that might send off the wrong signals too to your client. I mean, your client is paying you for your time to be there, and your client should have your undivided attention. So, of course, we've all seen that Zoom video of the court. I believe it was in San Francisco, with a doctor in the operating room appearing for a traffic court. And the judge was, rightfully so, said, we're not going to have this at this time. So just make sure that you carve out, if you're at 9 o'clock docket, get on there 10 minutes before. Undivided attention is warranted for your court appearance via Zoom.
And, part of that also laxed, if you will. Some people lax. The way they also speak to the judges in the courtroom has also changed during Zoom. Now, I understand that we're all trying our best, but we have been handling this for about a year. So the way you talk to the court and the court staff, while I understand it's been different for the past year since the previous years that you may have practiced law, you still do need to speak to the court and address the court and the court coordinator and the court reporters and the staff with respect that people deserve.
I agree with that. And I think we're coming into a time where everybody's a little unsure of how to proceed, and maybe a little antsy or anxious, or maybe one day the court says, hey, we're going to have these all by Zoom, or certain cases will be in person. Just remember, courtesy begets courtesy. And so if you call the court and seek questions or answers or such from the court administrator or the court coordinator, just remember that you're one of 50, 60, 100 calls during the day with questions like that. And while the staff doesn't mind answering your questions, just pay a little extra courtesy to the court staff. It goes a long way.
I agree. And, the court is aware that we're all in a very delicate situation. The court is also aware that we're in a very fluid situation, because things that were happening a month ago may not be happening now. And so, we're all just, like I said, trying our best, but still we have to treat each other with respect.
One other item I want to address is, and it's come up in our hearings, as lawyers, if your clients are going to appear from home, and maybe it's a stay-at-home mother or stay-at-home father, or the children are at home for whatever reason, make sure that you speak to your clients about ensuring that they have childcare at that time. These are adult conversations, and we don't allow children in court. So therefore, we need to make sure that we don't have tiny ears around that could hear sensitive information and information that should not be overheard by them. So make sure you vet your client in knowing that, okay, make sure the dog is put up, make sure the kids are safe with someone else, or, so that at least we have your client's undivided attention.
I agree. And at least in the 308th District Court, children are not allowed on the courtroom unless you have prior approval. And so that also means that you're in a courtroom when we are on Zoom, so your kids should not be present. These are very adult conversations. These are very adult things happening. And even if your child is of younger age and you think may not understand, this is still not the appropriate place to bring your child.
I agree.
Along those lines, you know, because we are prepping our clients, we also sometimes know who our witnesses are. And so we also, to an extent, need to prep our witnesses for how to use Zoom. If the witnesses are going to be appearing on Zoom. I know sometimes we have an elderly parent or an elderly grandparent who may be a witness, or even, that may have been wrong of me to say elderly, or somebody else who is not familiar with the Zoom technology. It takes, 10, 15 minutes of the court's time to figure out how to do something just so the court can swear them in and place them back in the waiting room if the rule has been invoked. So please also just be mindful of that when you are having a hearing via Zoom.
All right. And I would just recommend to everyone, lawyers and judges as such, always review the Texas Lawyers Creed from time to time. So it just kind of brings you back around to know what is in there regarding what the responsibility is we have as lawyers in the candor between the lawyers and the judge and the court. It never helps to review those things from time to time.
I agree with that. And along with reading the Texas Lawyers Creed, I also would suggest that attorneys, please also check out the policies and procedures of each court on their court's website or through their court coordinator, because a lot of answers are located in those court policies and procedures.
I agree. Well, I think we can segue into some questions at this time.
Sounds good to me.
Lindsay's with us, and I think she's going to be able to read some questions to us and see how we were able to answer those questions for her.
All right, thank you, judges. So I just wanted to ask a few questions generally about professionalism. First, speaking on what Judge Valdez was saying earlier regarding the staff and how busy they are, do you have anything that you would like to see attorneys do that's a little more professional towards staff, or any issues with professionalism that you see does not carry over to your staff that you wish would?
I just want to say, just try and be as friendly as possible to them. We hear when you're unkind to them. They tell us. And it doesn't make us happy. Also, they don't get paid enough to deal with people being as rude to them as people are. And it's not just one or two of y'all a day, it's a whole bunch of people being rude to them a day. And they're humans too. They're just trying their best.
Yeah, they have a job to do too. The one thing I do want to ask lawyers is to make sure and encourage your staff to be friendly. I think I get a lot of complaints from our staff that attorney staff is rude to them or very curt with them or very short with them. And sometimes they get questions of, my attorney wants me to file this. How do I do that? Well, our staff isn't here to, educate the lawyer staff how to do things. So just tell them to be mindful of their contacts, of what they're asking and how their presentation of the questions come across. And sometimes they get bombarded with hundreds of emails a day, and having a staff member from an attorney's office email 5 or 6 times on the same question, well, you haven't responded, I'm still waiting for your response. That's disrespectful to the staff too as well. And they're trying to do, plus keep in mind, and I know it's with our staff, they're managing 2 judges as well. So we're probably as equally as demanding as, attorneys are as well. So just make sure you take a deep breath, and when you ask a question, and I always tell our staff too, when they're responding, just smile on the phone or smile when you're composing your email goes a long way.
Oh, yeah.
And one thing we're taught as attorneys is to always be a zealous advocate for our clients. And then on the other hand, always be professional to opposing counsel. And sometimes those intersect. Well, oftentimes those intersect. Have you ever seen, or do you have an opinion on how attorneys can balance those two duties that we have, or ways that you can see that can be improved?
I mean, I think there's a difference between being zealous and being rude. You can be a zealous advocate and still be cordial and courteous to your opposing party or your opposing counsel.
Yeah, I agree with that too. And a lot of times attorneys, while they become zealous advocates, then they start aligning, and their client's fight becomes their personal fight. And I would just advise everyone, just don't make things personal. This is professional, and just don't take things personal in a sense that it becomes your fight instead of your client's fight. And just always remember, the rules of professionalism in that. Extend a courtesy. If you want someone to be courteous to you, you need to extend that courtesy to them.
I agree.
Along those lines, is there any time where it's appropriate to let the court know if you're having so much trouble with an opposing counsel during a case or during a hearing? Is there any time where it's appropriate to let the court know, or that you would like to know that, or should that be pursued through other channels?
I think there is a time when it is appropriate, especially if it's getting to the point where it's going to affect a setting or hearing. I've recently had a situation where an attorney says that their staff said that they were sick in bed with COVID, and an attorney refused to reset their temporary orders hearing, and they had to contact the court, because what else can you do? Their boss is laid up in bed, unable to perform their duty because he has an illness. And that's not just with COVID, but if you have the flu, or if, some other family emergency, it reaches to the level of the opposing counsel or opposing party isn't accommodating you, then sometimes you do have to reach out to the court staff.
Well, and I would never recommend ex parte in any way the court on issues that you're having. And not saying that you, Ryan, had said that, but just keep in mind, we sit and we listen, we hear and we see, and we can assess the interaction, and just by body language, interaction and such, whether it's in Zoom or in person, we're observant and we pay attention to all those things surrounding. So sometimes we get it. And then sometimes if there is an issue, I would always recommend approach rather than having the clients right there with them. And of course, this is probably more in person, but it just, say, we're having some difficulties communicating here between the two of us. And if that needs be, the court could interject itself at that time.
Thank you. All right. Is there anything that you would wish to see more regarding professionalism? Just in general, not just with Zoom, although I know a lot of your practices, a lot of your hearings are geared towards Zoom right now, but just anything you wish you could see a little bit more from attorneys regarding professionalism?
I think just continuing or try to be as cordial as possible, because some courts are doing Zoom, some courts are doing in person. People are sick or have family members sick, and we have been on lockdown for a year, or some sort of lockdown for a year. So, just try and be as accommodating to other people's what other people are going through as possible. I know it's hard. I know your clients want to be heard, and they want to be heard now, but just try and be as cordial as possible, because everybody is really just we're all just trying to navigate what's going on.
And I agree with that. And the attorneys that I've seen in on Zoom or in person, for the most part, we, the bar, both of the attorneys that I see up here in Montgomery County, are very courteous, very professional with one another. It's on rare occasions that I see interactions that I would deem as unprofessional. But we do all need to keep in mind that we're in unprecedented times with our clients, you know, again, wanting to get heard and wanting to get things done. And you know, the legal system itself has had to take a little a standstill and regather itself to figure out how we're going to navigate these waters with the COVID restrictions and stuff upon us. So I agree, just be courteous, be thoughtful, because, you know, if you refuse to cooperate with one attorney, it'll come back around to get you. And it's going to be a situation where, you know, you're going to need someone to cooperate with you. And, you know, if you have a reputation of being uncooperative, that's going to precede you. So it's just be courteous, be kind. It's all those things I guess we kind of learn in kindergarten, you know, be courteous, be kind with one another.
Last week, we lost a respected and beloved colleague, Bill De La Garza. Bill was a gentleman and a scholar. He was kind with old school manners that charmed everyone he met. He was generous with his advice and non-judgmental in his comments regarding our questions. Bill helped raise a daughter, Teal, our INSA court leader, who followed in her father's footsteps with a career in the law and service to the community. Bill's wife, Kimberly Levi, is also a dedicated attorney and a leader in our bar. So tonight, our hearts and prayers are with you, Teal and Kimberly. Bill set an example for all of us who respect professionalism and empathy. He had a sensibility for other people's feelings, and it served him well both inside and outside the courtroom. It contributed greatly to his success. So to you, Bill, tonight, I say, well done. Thank you for your years of service, and may you rest in peace.